I might add that the 8th and 9th Amendments, I could be wrong, maybe it's the 9th or 10th, both have the same basic limiting language of limiting those who are agents of the Crown, titles of nobility, as what it's claimed to be in the constitutional phraseology, are restricted from holding offices in government. And you're right, the TONA Act, the Titles of Nobility Act, the original 13th that was eradicated, sorry for the noise. Being a former multi-jurisdictional law enforcement professional and actual public servant to guard, protect, and defend against all enemies, foreign and domestic, as we're supposed to do, I had done quite a bit of research, and the shires of the Reve, the sheriff is where that comes from, the shire of the Reve, the sheriff, is supposed to be the highest officer of law enforcement in the county, although there's pretty good schools of thought that tell us that the coroner is the higher office. However, the sheriff office in many counties have been usurped by the county commissions, who, per their payment for employment contracts through the languages subject to the county commission, have usurped the power of the sheriff and made him act as an administrator, director of the police and sheriff's offices in the areas, and therefore they have stripped him of his ultimate authority and put them subject to the county commission's wishes. That's why, under the doctrine of agent superior and the law of agency, notice agency is notice principle, the county commission is one of the key people you want to go after if you're bringing a suit under a 42-1983 or a RICO or a Bivens action against these bad actors masquerading as public servants. Thank you.
Excellent insight, Chris. In Oregon, the statutes declare that the county commissioners have all the duties of a county court. Okay, and the county court is the proper terminology. That's common law terminology for county government. And the sheriff isn't the shire of the Reve, he's the Reve of the shire. The shire is another word for county. The word county is a French word. The word shire is Anglo-Saxon.
I stand corrected.
All right, thank you. And those in Oregon, the statutes clearly declare that the county commissioners have the duties of the county court, so that places them under common law jurisdiction. If you have the key ingredient is to bring a complaint before the county court, thereby with a complaint you're invoking the jurisdiction of the county court and giving it life. And when you have your complaint before the county court and the commissioners refuse to do their duty to function as county court officials, then at that point they're subject to removal from office, and we, the people, can move into the vacuum and take control of the government there. I do believe that's the optimal pathway. I should probably yield there. I yield.
Now, I can see that happening in Wayne County. I'm sorry. Go ahead. Somebody else.
No, go ahead with Wayne County.
Okay. Yeah, I was going to say I think I can see that happening in Wayne County because there's enough people, I believe, and Lewis can correct me if I'm wrong, there's enough people in Wayne County that would have a voice to be able to speak to the corruption of the Wayne County Commission and the long-term corruption that's been going on there. Speaking for myself and what I've seen of Oakland County before, I've made presentations to Oakland County that are pretty strong, along with some others in the Oakland County Commission, to let them know of the crimes that are going on, and it falls on deaf ears. A lot of them are bar attorneys, and if you go to, I wasn't sure if Charles was talking about when you go to the court, and if he was talking about seeing the commission as a court, or if he's talking about going to the court and pulling in the commission. But either way, the whole thing's run by bar attorneys. I yield.
I was going to make the point, if you'll allow me, that I've learned that we have to be very cautious with the terms we use and quantify them sometimes and to be specific. And I've learned that when I talk about common law, that there are several different forms of common law. And I want to preface it with the qualifier American common law, as it was founded in this country, being based upon the Anglican or the English, been a twisted man is what English means, common law, from the Magna Carta 1215. And so there are many things that we do that when we speak we have to be a little more careful how we qualify them, because when the bar attorneys talk about common law, they're talking about the jus divini, the law of the king, being the superior potentate and having all the powers that a despot would have, or a tyrant, and that's a very dangerous concept. So when we do these things, I think it behooves us to be cautious and be particularly explanative and to define our terms, as Voltaire says, or let them be turned against us as word war weapons and launched back at us to destroy us with our own words if we're not careful. Thank you.
Thank you, Chris. Yes, the devil is in the details, and using our words precisely is of extreme importance. I think you referenced, Chris, there that common law came from Magna Carta 1215. I would like to point out what I refer to as common law is an even more ancient version that was in existence prior to the Norman Conquest of 1066 AD. That's 150 years earlier than Magna Carta. And that was a pure form of common law that Mr. Blackstone recognizes is related to Israelite Torah law. Somehow, mysteriously, the laws of Israel have formed the basis of the common law that was in existence in England up until the Norman conquest of England in 1066 AD, and that's pure common law. What you're talking about is all the forked-tongue bar member attorneys are talking about different versions of common law that incorporates tyranny and despotism. That's because the Roman Empire model of government came into England in 1066 AD and adulterated and perverted the common law, the true common law, and they created a perverted form of common law where the juries and the sheriff were nothing less than sock puppets for the tyrant Roman emperor king who was posturing as being a Christian common law king, but he was really a devil-worshipping a Roman emperor that had his own god complex. And so there's only one real true common law. There are, as you say, multiple versions of the adulterated version of common law. There's English adulterated, perverted common law. There's American adulterated, perverted common law. There's Canadian and Australian adulterated. But we don't need to get tangled up in all that. If we're focusing on the real common law, where the power is really down at the townships and the precincts, then there's no wiggle room for those lawyers to smoke and mirrors us anymore. I yield.
I totally agree with you, Charles. The Creator's common law, the natural law of the Creator, is what we really want to ascribe ourselves to. And that first law is to do no harm and to have no gods before you, but before the Creator, no false images or graven images, as they call it. And I certainly agree with that concept. And this is where we've gotten way off path, is going down other versions that have been put forth, that the people have been bamboozled to believe that there's something higher than the Creator. Nothing can be, the created cannot be higher than the Creator. He's still the Creator ever. Never mind what the people do. It's very, very dangerous. So thank you very, very much.
Thank you, Chris. Others?
Yes, Charles Cliff.
Oh, hi, Cliff.
All right, how you doing? Okay, I just want to make a comment. I've heard what everybody said. They all make good sense. But we've got to form a third nation, like a common law group, like the Democrats and Republicans, because I don't know if everybody remember, but they put a movie out to tell you how they're going to always come out on top. And that movie was Too Big to Fail. So as long as they keep society thinking they're too big to fail, you're going to have to create another party and destroy this chaos we've got going on. And I yield.